Good afternoon, everyone. Good afternoon, everyone. Thank you so much for joining us today. My name is April Wepler, and I am the Engagement Coordinator at the Canadian Environmental Law Association, or CELA. Thank you for joining us for our webinar today titled Enhancing Environmental Accountability under the Environmental Bill of Rights, or EBR. We are talking today about the Law Commission of Ontario's discussion paper. I'd like to start with a land acknowledgement. I am in Guelph, and we are on the traditional lands of Anishinaabeg and Haudenosaunee peoples and on the treaty lands of the Mississaugas of the Credit First Nation and Six Nations of the Grand Watershed. I'll start by telling you a little bit about the Canadian Environmental Law Association. CELA is a specialty legal clinic within the Ontario-wide network of clinics funded by Legal Aid Ontario. We work to protect human health and our environment by seeking justice for those harmed by pollution and by working to change policies to prevent such problems in the first place. As a legal aid clinic, our top priority is to represent low-income individuals and communities and to speak up for those with less of a say in decision-making. We are pleased today to be co-hosting our session with the Law Commission of Ontario. The Law Commission of Ontario is Ontario's leading law reform agency. Since its inception in 2008, the LCO has completed 16 major projects and consulted with thousands of Ontarians on important law reform issues. They've completed projects on a broad range of legal issues, including defamation law, class actions, the law of capacity, joint and several liability, the Provincial Offences Act, division of pensions, RDSPs, family law, and laws governing older adults and disabled Ontarians. During the webinar today, we will hear from Nye Thomas and Ramani Nataraja of the Law Commission of Ontario, and Teresa McClenahan and Rick Lindgren from CELA. Also on the line with us today is Zoe St. Pierre, CELA's articling student. A quick bit of housekeeping before we get started. We are hosting today on Zoom webinar, so you'll note that your mics and cameras are turned off. You are welcome to introduce yourself, share a land acknowledgement, share any comments that you would like to in the chat box. The chat box is available to you. We would encourage you to ask your questions in the Q&A feature. So that's the little icon on the bottom of your screen that you can click on and ask your questions. You can also see other people's questions and respond to them or upvote them if you like them. And we will take some questions at the end of the webinar. We are recording today's session and we'll post the recording on our website after the session, as well as sharing it with everyone who registered. So with that, first up today, we will hear from Nye Thomas, Executive Director of the Law Commission of Ontario. I'll pass it over to Nye.
Thank you, April. And on behalf of myself and the Law Commission, I'd like to thank CELA for organizing this webinar, this consultation session. I'll say at the outset that CELA's voice and your stakeholders are very, very important to this project. You're the experts on this more so than anyone, and your input, your advice, your comments, your thoughts are crucially important to the success of this project, and I want to reiterate again my thanks on behalf of the Law Commission. I'll give you the kind of 2-minute update on the project, and then perhaps turn it to Teresa, Rick, and Ramani. We're the Law Commission. As April says, we're a law reform agency located at Osgoode Hall Law School here in Toronto. Our environmental accountability project has actually been several years in the making. The project looks at, first, the Environmental Bill of Rights, which at this point I think we all appreciate is quite dated. But then it also looks at more contemporary environmental issues that are not accounted for in the Environmental Bill of Rights, but have to be accounted for in any kind of thoughtful and contemporary analysis of environmental accountability. So, a right to healthy environment, environmental justice, Indigenous legal orders, and the like. So our project really tries to get a handle on both some of the specific reforms that might be necessary to the EBR, but also to get some advice from stakeholders, the public, and others on how environmental accountability can account for these newer ideas, urgent, important ideas in light of climate change and the needs of the province. The consultation is in the early stages. We are seeking lots of people's advice from across kind of the political spectrum, if I can put it that way. There are many opportunities to get involved. This is just one. If I'm sure I'll hear from Romani that if you'd like to get involved, you can email us, you can phone us, you can provide input in writing, however you choose, and we will read everything and take everything into account. And all advice is good advice, irrespective of whether it's on one question, 10 questions, every question, one aspect of one question. It's all good. It all goes into the mix, and we take everyone's opinion seriously. With that, April, unless you think I should add anything else, I will pass it off and pass off the baton to perhaps Teresa, Rick, and Romney. I'm not quite sure who's going next, but unless you think I should add anything else, I think my work is done here. So.
Perfect. No, that's great. Thank you, Nye. Appreciate that. So with that, we will pass the virtual mic over to Teresa McClenahan, who is Executive Director of CELA.
Great. Thank you, Nye, for that. And thank you, April. Thank you, all of the people who've joined us for the webinar today, and to the Law Commission for undertaking this study, which is really timely and really important at this point in time. So I'm going to spend a couple of minutes talking about some of the key EBR provisions, Environmental Bill of Rights provisions that are under review by the Law Commission, just to kind of set the stage for the more detailed presentations with PowerPoints that both Richard Lindgren from CELA and Ramani Nataraja from the Law Commission will be providing to you. Along with the discussion questions. So first of all, there's a section of the Environmental Bill of Rights that's called the Statement of Environmental Values. So to give you a little bit about that, the EBR requires certain ministries that they prescribe to develop and occasionally update statements of environmental values. And then it requires ministers to take every reasonable step that SEV, I'll call it, is considered when the ministry is making decisions that might significantly affect the environment. And at present, there are over about a dozen ministry SEVs that you can see on the environmental registry. You could think of them as high-level mission statements, is the tenor most of them take right now, that address the purpose of the EBR, and they provide some direction to ministry staff, whichever ministry it is, when decisions are being made about environmental laws, regulations, policies, or instruments like licenses, permits, and approvals. But as Ramani and Rick are going to explain, there's good reason to believe the SEVs are not greatly influencing government decisions, policies, or programs, and not working as well as they were originally intended when the EBR was first drafted in the early 1990s. The second key piece that is under discussion is the Commissioner of the Environment. And in 1993, when it was first enacted, the EBR established the Environmental Commissioner as an independent officer appointed by and reporting to the Ontario Legislature. And that officer over the years acted as an environmental watchdog, reported directly to the Legislature on the Ontario government's compliance with EBR duties, as well as made important recommendations on key environmental matters like climate change, biodiversity, aggregate extraction, land use planning, and many others. And the last commissioner in that framework was well-known environmental lawyer Diane Sachs. But after Bill 57 in 2018, that independent office was terminated, and some, but not all of the powers were transferred to the Auditor General of Ontario and the Environment Minister. We think the Auditor General's done a good job over the years, and more recently in the new incarnation under the EBR role itself, but some observers are concerned that the sudden termination of the ECO office may have reduced environmental accountability and oversight in the long term. The third area is leave to appeal instrument decisions. So just to give you perspective on what that is, under the Environmental Bill of Rights, it's possible for concerned citizens to apply for leave or permission of the, now it's the Ontario Land Tribunal, that they could appeal certain environmental approvals. And those decisions are made by the OLT, which is a specialized and quasi-judicial administrative body. The leave process is conducted in writing, and then if it's granted, the appellant could file a notice of appeal, and then there are hearing procedures, and the tribunal could uphold the decision they're reviewing or change it or quash it. But the leave test sets quite a high bar. The applicant must persuade the tribunal there's good reason to think no reasonable person, having regard for the law and policy applicable, could have made the decision, and that the decision could result in significant environmental harm. So it's not surprising maybe that given that strict test, most leave applications are actually dismissed. And so it's appropriate and necessary to revisit that leave test after the over 25 years of experience with it under the EBR that we have had. The fourth area is judicial review constraints under the EBR. I believe both Ramani and Rick are going to talk a little bit about the balance that was struck between political accountability and legal accountability. So suffice to say at this point that the EBR leans more heavily on political accountability mechanisms like those statements of environmental values, the special and annual reporting under the EBR to the legislature, rather than the legal accountability mechanisms like judicial review. There is a provision in the current act that no governmental decision under the EBR can be reviewed in any court with just limited exception. And so again, it's time to reconsider this because of the limited public access to courts that provides. So with that, I will turn it back to April to introduce the next speaker.
Great. Thanks very much, Teresa. So our next panelist today is Ramani Nataraja, who is counsel at CELA and is currently on secondment to the Law Commission of Ontario as project head of the Environmental Accountability Project. And Ramani, just remind me, are you sharing your own slides or is Zoe putting your slides up for you?
Thank you, April. I'm going to be sharing my own slides.
Great. You can go ahead and screen share now then.
Thank you very much. I'll just do that right now.
Looks good.
Okay. Thanks, April. So as April indicated, I'm going to discuss the Law Commission's consultation paper, which is titled Environmental Accountability in Ontario, and that paper can be found on the Commission's website. The consultation paper undertakes a comprehensive review of the Environmental Bill of Rights with a view to improving environmental accountability. And the paper poses two main questions. First, whether reforms are required to the EBR. And secondly, we ask whether Ontario should adopt other strategies to ensure environmental accountability. And Nye Thomas has already mentioned some of these. These include environmental justice and whether the right to a healthy environment should be incorporated into the EBR. In undertaking this project, we reviewed quite a number of documents. The key ones were the report that was prepared by the Task Force on the Environmental Bill of Rights. The task force was established about 30 years ago by the then Minister of the Environment, Ruth Greer, and it was intended to provide recommendations on a draft bill. And I found it extremely helpful to go through the task force report because I think it really provides a really good overview of how the EBR was meant to be implemented and to operate. We also reviewed the reports that were prepared by the Commissioner of the Environment as well as the Auditor General of Ontario. These reports have been very critical of some of the government ministries' failure to comply with the EBR. And finally, we also reviewed some recent court decisions, which have also been critical of the provincial government's failure to comply with the EBR. In designing the EBR, as Teresa's mentioned, the task force relied largely on a political accountability model. And the task force described this approach as one that does not use the courts to control government conduct, but rather empowers individual residents of the province to play a role in protecting the environment. And so this meant that under the EBR, access to the courts was left as an exercise of last resort. So a very fundamental question that we raise in the consultation paper is whether the EBR's emphasis on political accountability remains a viable model, or whether there should be more mechanisms for legal accountability. And by that, I mean, should the public have greater access to the courts to address government action or inaction? And this is really a very central issue, given that, as I mentioned earlier, there have been reports by the Environment Commissioner and the Auditor General, which have sort of outlined, I think, a systemic non-compliance by government ministries with the EBR. The two main pillars for in the EBR for addressing political accountability are the Statement of Environmental Values, generally referred to as the SEVs, and the Office of the Environment Commissioner. The SEVs were supposed to play an important role in ensuring that the purposes of the EBR would be reflected in government decision-making. The task force expected the SEVs would serve as a mission statement, as Teresa has mentioned, and they would also serve as a sort of a strategic plan for government ministries by establishing specific goals and the means to achieve them. And government ministries were supposed to explain through the SEVs how the EBR's purposes would be integrated into the decision-making process. It's important to note, however, that the SEVs were not intended to serve as a guarantee that the EBR's purposes would, in fact, be embodied in ministries' decisions. Rather, the SEVs were intended to ensure that the EBR was considered by government ministries in decision making. So in other words, environmental considerations, just like any other factors, social, economic factors, were meant to become a component in the government's decision making process. Both the Environmental Commissioner and the Auditor General have been critical of the government ministry's failure to implement the SEVs. The Environmental Commissioner has stated that SEVs, which have been prepared by government ministries, some of them were vague. They lacked details on how ministries would integrate environmental considerations into their decisions, and often failed to provide clear objectives or measurable goals. Furthermore, the scope of the application of the SEVs has also been a very divisive issue. In the past, the Environment Ministry has taken the position that SEVs only had to be considered when the ministry developed legislation, but not instruments. And instruments are things such as government permits, licenses, approvals, and orders. And that position was rejected in an Ontario Divisional Court case, Lafarge, Canada Inc. versus the Ontario Environmental Review Tribunal in 2008. And the ministry's position is also at odds with how the task force envisaged the operation of the SEVs. The task force report clearly states the SEVs were to apply not just to policies and legislation, but to the actual instruments. That's where the actual permits, approvals, licenses. So one of the questions we asked in the LCO's consultation paper is whether the SEVs should be strengthened to improve government accountability, and if so, how? The second pillar for ensuring environmental accountability under the EBR was establishing the Office of the Environmental Commissioner of Ontario. The Environmental Commissioner was absolutely central to the political accountability model. The task force recommended that the Environmental Commissioner be appointed by the legislature as opposed to the government of the day, and be required to report directly to the legislature. And this was done to ensure that the Environmental Commissioner would be independent and impartial. The Environmental Commissioner was also expected to provide annual and special reports on the implementation and operation of the EBR. The task force assumed that the Environment Commissioner's report would provide this sort of objective, non-partisan analysis, which in turn would lead to political accountability. In 2009, the Environment Commissioner's responsibilities were expanded to include reporting on the province's progress on climate change and energy conservation. And then as Teresa mentioned, 10 years later in 2019, that the government passed the Restoring Trust, Transparency and Accountability Act, amending the EBR and making very significant changes to the Environment Commissioner's role. The Environment Commissioner's responsibilities were transferred to the Office of the Auditor General of Ontario. And as a result of these amendments, the Environment Commissioner is no longer appointed by the legislature. Instead, the Environment Commissioner is now an employee of the Auditor General and is expected to perform the duties assigned by the Auditor General. The Commissioner still remains responsible for overseeing and reporting on the operation of the EBR, but is also required to lead the Auditor General's value for money audit. Furthermore, the requirement that the Environment Commissioner report on the Ontario government's progress in energy conservation and addressing climate change is no longer mandatory. Instead, the Auditor General now has discretion to determine whether the Environment Commissioner will continue to report on these issues. The Environment Commissioner also previously had a statutory mandate to educate the public about the EBR, and that duty has now been transferred to the Ontario Environment Minister. And this may, some have said that this could be problematic given that the Environment Minister and his staff are generally usually the respondents in proceedings brought by the public under the Act. So concerns have been raised that it's unrealistic to sort of expect government officials to provide advice on to the public on how to effectively use the EBR to hold the government accountable. So one of the questions we raised in the consultation paper is, should the Environment Commissioner's powers be strengthened, and if so, how? Teresa has touched on the leave to appeal provisions. The leave to appeal provisions have provided a really important mechanism to the public to challenge permits and approvals and other instruments issued by government ministries. However, the test for leave, as Teresa mentioned, is really quite high, with the result that very few leave applications are granted. And the primary purpose of establishing a leave test was to prevent this sort of floodgate of leave applications and to sort of screen out frivolous and weak cases. But it's worth noting that between 2009 and 2019, there were on average only 5 leave applications per year, and leave was only granted in 21% of those cases. So given the really sort of low number of applications for leave to appeal, questions have been raised whether the Section 41 leave test unduly restricts access to justice. And this may be particularly the case now that the Ontario Land Tribunal's new rules of practice and procedure allows the tribunal on its own initiative to dismiss a matter without a hearing, where it determines the matter is frivolous, vexatious, commenced in bad faith. Furthermore, the timeline for filing the leave application is also very tight. The leave application has to be filed within 15 days after notice of the decision is placed on the registry. So with respect to the leave provision, one of the questions we ask is whether it's necessary to improve access to justice under the EBR, and if so, are amendments required to the leave to appeal test? Teresa has also mentioned the broad privative clause in the EBR. Section 118.1 of the EBR restricts judicial review of government action. And then under Section 118.2 of the EBR, judicial review is only available if a government ministry has failed to comply in a fundamental way with the public participation requirements under Part 2 of the EBR. The EBR doesn't actually define what constitutes a fundamental noncompliance. A number of legal commentators have said that this may include situations where the government has failed to provide notice under the EBR or has not complied with mandatory time requirements for comments. The EBR also places restriction on the scope of judicial review through Section 37. Section 37 states that the failure to comply with public participation rights under the EBR does not affect the validity of any policy, act, regulation, or instrument. In other words, the remedy that the court can award for a breach of public participation rights is quite limited. So for example, last year in the case of Greenpeace Canada versus Ontario Minister of Environment, the Ontario Divisional Court found that the Minister of Municipal Affairs and Housing had acted unreasonably and unlawfully by failing to consult with the public before making changes that had significantly enhanced the minister's power to issue zoning orders under the Planning Act. Now, even though the court made a finding that the minister's actions were unlawful, it held that because of Section 37, it could only issue a declaration that the minister's actions were contrary to the EBR. It could not quash that actual decision. So the LCO's consultation paper asks the question of whether the EBR's restrictions on judicial review and the restrictions on remedies are in fact appropriate. As I mentioned earlier, the Law Commission consultation paper not only looks at reforms to the existing provisions of the EBR, but it also looks at whether Ontario should adopt one or more contemporary strategies regarding accountability for environmental accountability. Two such strategies that are considered in the paper are environmental justice and the right to a healthy environment. And I'm now going to turn to deal briefly with each of these strategies. At the time that the EBR was enacted, environmental justice was not a prominent concept in Canada and was not addressed in the task force report. Since then, environmental justice has become an important framework for assessing whether environmental risk and burdens are distributed fairly in society. Studies have shown that low-income and marginalized communities in Canada, including Indigenous communities, are disproportionately impacted by pollution. United Nations Special Rapporteur's report published 2 years ago concluded that low-income communities in Toronto and Hamilton face a disproportionate burden of exposure to pollution. And Indigenous communities were found to face a greater exposure to hazardous substances than the rest of the pollution. At the federal level, there have been recent efforts to address environmental justice through private members' bill that were introduced in the House of Commons. These include Bill C-219, the Canadian Environmental Bill of Rights, and Bill C-230, the National Strategy to Redress Environmental Racism Act. So one of the questions we raised in our consultation paper is whether the EBR should impose a statutory duty on government ministries to engage with low-income and marginalized communities during the environmental decision-making process. Another strategy we have considered incorporating was incorporating the right to a healthy environment in the EBR. At the federal level, the right to a healthy environment was recognized for the first time in Bill S5, Strengthening Environmental Protection for a Healthier Canada Act. However, that federal bill has been criticized because it fails to provide a mechanism to for the public to actually enforce this right. Now, the right to a healthy environment has really grown exponentially at the international stage. At least 89% of the member states of the United Nations have adopted a right to a healthy environment in some format. And earlier this year, the United Nations General Assembly adopted a resolution declaring access to clean, healthy, and sustainable environment as a human right. Consequently, the right to a healthy environment, we think it's a very important issue that warrants consideration under the EBR. But that being said, it's a very complex issue and raises many important questions about how such a right could or should be recognized and implemented. So for example, how would the right be defined? What level of environmental quality should be protected? Should it be limited to just cases where pollution has caused health impacts, or should it be framed more broadly? Thirdly, who would be the beneficiary of the right? Would it apply to any resident in Ontario? Should any resident in Ontario be allowed to bring a cause of action for a right to a healthy environment, or should it only be restricted to those who are in fact impacted by pollution? Fourthly, should the right be enforced against just the government, or should it also include private actors? And finally, the question we ask is what are the appropriate legal remedies? Should the remedy be restricted to monetary damages, or should the remedy be restricted to restoration of the environment, or both? So these are really fairly complex questions that we are really soliciting feedback from the public on. So as I've mentioned, the consultation paper is available on the Law Commission's website, and I would encourage all of you who are interested to provide comments. There's no need to comment on the entire paper. If there's only 1 or 2 issues that are of interest to you, please provide comments on them. The consultation period is open till November 25th. And I would encourage all of you to write in, because we will take all comments that are provided. We will review them and take them into consideration. So thank you for your time, and I will now turn it over to Rick.
Great, thank you,
very much,
Romney.
Romney.
And good afternoon, everybody. Perhaps Zoe, if you can pull up my slides, thank you so much. Well, I'm basically here to do two things. First, explain why this Law Commission consultation is so important. And secondly, I hope to provide some answers to the questions that Romney just reviewed during her presentation. So perhaps we can have the next slide. What I'd like to do first is provide a bit of context, a bit of background for my own presentation. First, as you know, CELA has been a long-time advocate of the Environmental Bill of Rights, and that's why CELA was appointed to the Minister's Task Force that actually drafted the Environmental Bill of Rights back in the day. And I was fortunate enough to serve as CELA's representative on that task force. Then when the bill was enacted in 1993 and proclaimed into force in 1994, CELA staff have actively used all of the EBR legal tools. And I think it's fair to say that on the basis of our 25 plus year experience with the EBR, we have a good sense of what works, what doesn't work, and what needs to be fixed under the EBR. So that'll be the gist of my presentation today. And perhaps I'll have the next slide, please. In a nutshell, CELA takes the position that it's time to strengthen and improve the Environmental Bill of Rights. It's time to bring it into the 21st century. As Nye mentioned, it's a little bit stale dated at this point. It's vintage 1990s thinking on environmental protection and natural resource conservation. I think we need to move the yardsticks forward. And that's not just CELA's view, that's the view that's been expressed over the years by the Environmental Commissioner of Ontario and by other environmental groups and other stakeholders. There's recognition that things need to be amended to make the EBR more effective and to ensure that it actually meets its stated purposes of environmental protection, public participation, and government accountability for environmental decision-making. And in the bottom of the slide, I refer to the fact that in 2010, CELA used the EBR to file an application for a review of the EBR. And in 2013, the Environment Ministry agreed that it was in the public interest to review the EBR. And so in 2016, 2017, the ministry conducted a very limited consultation program in relation to potential reforms to the EBR, but the net result was no changes were made to the EBR. So fast forward to 2022, I have to say I'm very happy that the Law Commission has picked up the ball and they're going to run with it in terms of EBR reform. And I'm hopeful that they score a touchdown. We'll take the next slide. Thank you. I'm not going to spend too much time on this. Romney's already indicated that the commission is consulting on some pretty important broad concepts, rights of nature, public trust, et cetera. But the discussion paper also poses a number of specific questions about technical amendments that could be made or should be made to the EBR. And some of those EBR issues are listed at the bottom of the slide. And I'll go through them one by one, but I don't want to leave you with the impression that these are the only EBR issues worthy of consideration. The discussion paper actually poses 16 different groups or sets of questions, and there's a lot of EBR amendments that are discussed, but I don't have time to deal with them today. We'll deal with them in due course. So I think next slide is we're ready for that one. Okay, so let's talk about statements of environmental values, or SEVs, as I like to call them. And I won't dwell too much on the current suite of SEVs. They do contain some fairly high-level environmental principles and other commitments made by the ministries, and the ministries are compelled to at least consider these SEVs when they're making environmentally significant decisions. And as Romney, I think, made reference to the Lafarge case, that was a situation where the divisional court held that statements of environmental values are part of the environmental law and policy framework that need to be considered when ministry officials are considering the issuance of environmental approvals. And I guess in the interest of full disclosure, I should mention I represented two parties in that case. So so far so good. We've got a court ruling that says the SEV content needs to be at least considered by ministries when making environmentally significant decisions. But if we go to the next slide, I have to say the overall SEV track record is a bit disappointing. I should have mentioned earlier, you'll see a number of hyperlinks sprinkled throughout my presentation. That'll take you to some supporting documentation. This one takes you to a blog written by my co-counsel at Seal Joke Australia, where he outlines the rather, I guess, dismal history of SEV implementation under the current regime. And I think most of the problem is attributable to the fact that there's not a lot of prescriptive detail in the SEVs, and it's hard to hold government's feet to the fire in terms of applying or not applying the important environmental principles that are outlined in these SEVs. So how do we fix that? Well, my bottom bullet point here on this slide suggests a few possible reforms. I think number one is to start by amending Section 11 itself. That just merely compels ministry decision makers to consider SEVs. So you have to tip your hat to it. You have to take them into account. But it falls very short of imposing a mandatory duty to actually apply the content of an SEV. That is why, in my view, it would be useful to amend Section 11 to specify that all government decision making shall be consistent with SEV content. I think that would be a very significant improvement, particularly if it's accompanied by a rewrite of the SEVs themselves. I have to say that when the SEVs were first introduced in the early 1990s, we at CELA were not very impressed with their content. In fact, I recall calling the SEVs eco-fluff at the time. And I would have to say, even though the SEVs have been revised from time to time, nothing really substantively has changed. They're still fairly high level in nature. I think they need to be beefed up in terms of substantive content. The final thing I mentioned on this slide is the need for the ministry to publish or web post SEV documentation that explains with reasons how a particular ministry decision conforms to or is consistent with the SEV requirements. Again, some of that's being done by some ministries behind the scenes, but I would like to see more public accounting of how these SEV considerations like ecosystem approach or precautionary principle, cumulative impact assessment, how did that factor into the environmental decision that's being made? So I think there's lots of room for improvement in terms of ensuring SEVs are not just considered, but actually applied on the ground when these really important ministry decisions are being made. So we'll go to the next slide. And then, as Rami and Teresa mentioned, there are some concerns about the current role and duties of the Commissioner of the Environment under the EBR. And as Teresa pointed out, the current Commissioner of the Environment is not an independent officer of the Ontario Legislature. He or she is an employee of the Auditor General. And as Teresa indicated, some of the eco duties were given to the Auditor General, some were given to the Environment Minister. But I encourage you to take a look at the 2021 report of the Auditor General, who not surprisingly found that the minister really had done nothing or little to perform the public education and outreach task. So, you know, it's difficult to criticize folks for not using their EBR rights more extensively or more aggressively because they may not know they exist, or they may not know how to use them. So I think there's room for improvement there. And in terms of the overall fix, I would certainly support the restoration of the Eco Office as it was originally envisioned by the task force and implemented in the original Environmental Bill of Rights. I think the Eco Office needs to be given back its full set of powers and duties and responsibilities, including making it mandatory for the office to report on energy conservation and climate change matters. It would also be helpful to have timely government answers to eco reports or recommendations. Over the years, the Environmental Commissioner's Office made a number of really important recommendations in terms of legislative and regulatory and policy reform under the EBR. Most of the time, this disappears into a black hole or a black void, and nothing gets done. And we don't know whether to what extent these recommendations have been even considered internally by the various ministries. And I hasten to add that none of this is intended to be a criticism of the current Auditor General. I think she's done a great job under the EBR so far. I really like her first two EBR annual reports that were filed with the legislature. They're hard-hitting, they're evidence-based, they're well-founded in terms of their findings and recommendations. And I look forward to her next annual report to the legislature, which hopefully will come out in the next month or two. So keep an eye out for that. So I think that's all I wanted to say about the Commissioner of the Environment for now. If we can go to the next slide. And Teresa and Romney have already touched on this. I see the leave to appeal provisions under the EBR as a very important accountability mechanism, but there is concern that this two-part leave test is too strict. In my view, it's keeping out too many cases from even reaching the Ontario Land Tribunal. I think it was Romney who pointed out most of the time leave applications are dismissed. And what's the fix for this? Well, I would say, first of all, we should reconsider and perhaps relax some of the standing requirements that need to be satisfied by people who want to appeal instruments to the Ontario Land Tribunal. But most importantly, I think we need to delete the leave test in its entirety. As I note on this slide, proponents do not require leave to appeal if they don't like the minister's or the ministry's decision on an instrument application. So if the ministry says no to the application, or if the ministry imposes terms and conditions that the proponent doesn't like, the proponent can appeal as of right to the tribunal. I say, if we're serious about environmental equity, if we want to level or balance the playing field, I would say concerned citizens should also not have to seek leave to appeal, just like proponents. And although there is some concern that this is going to result in the floodgates, I think Romney in her presentation has already addressed that concern. Thousands and thousands of instrument notices get posted on the environmental registry every year, and just a mere handful are subject to a leave application. So I doubt that removing the leave test is going to significantly result in hundreds and hundreds of leave applications, keeping in mind that, in order to, get to the tribunal and have some prospect of success, you probably have to, hire a legal team and a team of experts in order to present your case if you're a public interest appellant. So it's not going to be easy to appeal, even if the leave test is removed. Romney also mentioned that the leave time frame right now is 15 days. At the very least, it should be 20, and preferably maybe 30 days. It takes a long time to assemble your case and put it forward if the leave to appeal mechanism is going to be retained. I think that's all I'll say about leave to appeal. Maybe we can move to the next one. So buckle your seatbelts. Here comes a little legalese. Teresa and Romney have already mentioned this, but there are certain constraints in the EBR that really limit or restrict public access to the courts. Section 37 basically provides that even if the government does not comply with the consultation requirements of Part 2, that does not affect or invalidate the act, the regulation or policy at issue or the instrument. And as Romney pointed out, Section 118 basically prohibits judicial review in most instances, except for situations where the decision maker fundamentally failed to comply with the EBR in relation to consultation on an instrument. Next slide, please. And so Romney discussed this, the Greenpeace 2 case that was recently decided in 2021. And again, full disclosure, we represented some folks who were judicial review applicants in this case. And as Romney indicated, the divisional court ultimately held that the Minister of Municipal Affairs and Housing acted unlawfully and unreasonably in making the changes to the Planning Act that enhanced the power to issue ministerial zoning orders. So the court issued a declaration to that effect, but effectively Section 37 prevented the court from quashing or setting aside or striking out those provisions. And so they're still in the books, they're still intact. And I think that highlights a bit of a difficulty. So to fix this problem, I take the hard line. I think Section 37 and Section 118 need to be deleted. I think the scope of judicial review needs to be expanded to include whether or not government decisions are complying with improved or strengthened SEV content. And I also think that the court should be expressly empowered to provide a broader range of court remedies in appropriate cases, and I've listed a few of them here. And in my view, I think that broader range of remedies, if issued, would probably get the government's attention and hopefully will deter EBR non-compliance by the government in the future. So we'll go to the next slide, please. So there are also, as I mentioned, some broader questions about big ticket or big picture legal concepts. And the LCO wants your input as to whether or not some of these things should be incorporated into the EBR, and if so, how. The first question is whether or not the EBR should entrench a substantive right to a healthy environment. And in my view, the short answer is yes. And on that point, I provided on the slide an excerpt from Bill C-219, which Romney referenced. And it's a good illustrative example of how a right to a healthy environment could be built into law. I recognize that reasonable people may differ on the precise wording of the right. There are different ways to articulate the right and build it into a statute. But I think there can be no dispute from the public interest perspective that the right to healthy environment belongs to or should go into an environmental bill of rights. In my view, the continuing absence of a substantive right to a healthy environment in the EBR is probably the biggest single omission from the environmental bill of rights. I will tell you, this was a matter of intense discussion amongst the task force back in the day, but it's a live issue today, and it's time to revisit whether or not a substantive right needs to be built into the EBR so that the EBR is not simply a collection of procedural rights. So we'll go to the next one, please. Then the Law Commission's discussion paper also asks whether or not environmental justice considerations should be built into the Environmental Bill of Rights. I say again, the short answer is yes. And I've provided an illustrative example again from Bill C-219, which in part, entrenches or partly defines what environmental justice is all about, which is ensuring that low-income communities or vulnerable communities are not disproportionately impacted or burdened by pollution sources. So I should note that Bill C-219 is a federal private members bill. It may or may not be passed by Parliament, but really, I see no constitutional impediment to having the Environmental Bill of Rights here in Ontario include environmental justice purposes and principles and provisions, so we get so as to avoid further or additional environmental injustices in this province, like the Grassy Narrow situation or the Chemical Valley situation near Sarnia. It's time to get moving on environmental justice, in my view, in Ontario. We'll go to the next one, please. Then there's the question about whether or not the public trust doctrine or legally enforceable rights to nature or rights of nature should be embedded in the Environmental Bill of Rights. We haven't really talked about that very much yet. Just in a nutshell, the public trust doctrine basically stands for the proposition that governments do not own natural resources. They hold them in trust for you and me, members of the public. And if the government does something inconsistent with that fiduciary duty, if they authorize or undertake actions that adversely affect the subject matter of the trust, then people should be able to go to court and get a remedy to get that addressed. That was a situation that arose in the infamous Green case from the 1970s. I like to use it from time to time. This is a situation where a private person unsuccessfully tried to go to court to protect some unique sand dune ecosystems in and around Sandbanks Provincial Park in Eastern Ontario. And as mentioned, that attempt was not successful. the court held that this private individual had no standing or status to actually go to court to protect nature. And more importantly, the public trust doctrine, as I've just described it, did not apply to provincial parks or the resources therein. So I think we want to avoid that situation. I think we want to be able to have the residents of Ontario go to court to go to bat for natural resources in appropriate cases. And again, bottom of the slide provides an illustrative example from Bill C-219, which attempts to entrench or establish a public trust duty on the federal government. I see no reason why we couldn't do the same under the EBR within the legislative competence of the Ontario legislature. So next slide, please. Okay, so these are the next steps. It probably goes without saying that we at CELA will be preparing and sharing a fairly detailed response to all of the questions posed in the Law Commission paper. If time permits, we might do a joint sign-on letter. I don't know, we're kind of hard pressed these days dealing with other issues. Ideally, I'd like to draft a model bill, but I don't know if I'll have time to do that either. But this is an important consultation, and we do very much encourage all of you to participate in the process. And if you decide to get involved in the process, if you have questions about this issue or that, please feel free to contact us at CELA. And that brings me to my final slide. This is a collection of some resources or some references that you might find helpful if you do participate in the Law Commission consultation. I encourage you to look at the website. There's a hyperlink in the first bullet point. As you might suspect, here at CELA, we have a fairly extensive of EBR materials. Actually going back, way back decades, you don't have to go back that far. I've also provided a hyperlink to the Auditor General's 2021 report, which does provide a good overview of various instances of government non-compliance with their various EBR duties and responsibilities. And finally, some textbooks that you can consider if you want a more detailed look at what the EBR is and what it's supposed to do. So with that, I think that concludes my presentation. Thank you for your attention. I'll toss it back to April.
Great. Thanks very much, Rick. All right, so I'll just address a couple of quick logistics questions in the chat in case anyone is not able to scroll as quickly as the questions and comments are coming in. So I just want to reassure everyone that we are recording the session and we'll post the recording. We will also post the slide decks, and that means you'll also have all the links that Rick posted because those are all linked in his slide deck. So those will go up on CELA's website and they'll also go out via email. So you will have access to all of those for anyone who was trying to frantically capture all of those links. All right, we have a lot of questions in the Q&A and a couple in the chat. So I've been taking note of some of those questions, but before I suggest one, I want to see if any of our panelists have also been scrolling the Q&A and have pulled out any questions that they want to make sure they respond to.
April, I can respond to a couple, and I've noticed a couple that it might be appropriate for Nye and or Ramani to address. So for them to start thinking about that, there's a question right at the very end about the Law Commission paper and other government objectives, so you could consider about that. There's also a question earlier about how does the paper get considered? Is there an obligation for anybody to respond to it? There's an accountability type question vis-a-vis your report. Similarly, there's a comment, I guess, about will this paper make a difference? Is anyone compelled to respond to it? So a similar type of comment. So those I'll flag. Maybe you could deal with in a minute. In terms of other ones, I noted there's a question about ongoing legal accountability after a minister has completed tenure. So a minister is has both a political function and an executive function. And so once they are no longer minister, if there's something that they did as minister, the Crown will still respond to whatever that request or court action or whatever it might be. It's not personal to the minister holding that chair. So that's a very short answer to that. In terms of some of the comments also, because this chat will be collected and provided to the Law Commission. So some of the things people have commented, that some of the barriers and so on, very good comments, and those will be provided to the Law Commission, like the fees and that kind of thing. So before going back to April to pull out any other questions, I wonder, Naya or Ramani, if you want to address those ones about the paper itself and where it goes from here and that kind of thing.
I mean, I can take a crack at both of those questions, and I'll sort of divide them into sort of the accountability question, what happens to our reports, and then there was a further question about balancing, like how we balance different interests and whether or not that's a component of the report. And I'll answer the second question first. And the short answer is yes. We are independent, we're nonpartisan. We try to think about the public interest, and I appreciate that's a variable term that has a lot of potential different interpretations. We're not an advocacy group, so it is our job, if we do it well, to look at issues thoughtfully and from a principled basis, talking to all stakeholders, speaking to all various interests and organizations who might be involved in an issue, and to consider their input and their advice to us, fairly and thoughtfully. And then again, if we're doing our job well, we come up with a report that is principled, it's practical, and it solves some problems. Some people like all of our reports. Some people don't like all of our reports. I will assure you that irrespective of whether we ultimately agree with a recommendation from CELA or from someone else, that all views will be fairly represented in the report. So if there is someone who makes a submission to us, a perspective, stakeholder perspective that we're aware of, we'll do our best to represent that fairly and to allow everyone to put their best foot forward, and we'll analyze it. What I hope, again, if we're doing our job well on a kind of fair and principled basis. So that's kind of our job. And then the first question was, which is an important one, is, what happens to our reports? Does the government have any obligation to implement it, to react to it, to respond to it, anything like that? And the short answer is no. There is no, we read our reports, we submit our reports. Our track record is sometimes our reports are implemented, sometimes they aren't. Sometimes they are implemented years after the fact. Our goal when we're writing our reports is not just for the issues of the day, but we're writing for the long term. So we tend to deal with bigger issues that are going to be around for a long time. So the concept of environmental justice or right to healthy environment or the EBR, these issues are going to be around for a long time, and we'll no doubt we'll still be talking about these issues, during the term of this government, into the term of the next government, and to the term of the next government after that. So irrespective of whether one government picks up our specific recommendations or not, our job, again, assuming we do it well, is to be a resource for legislatures, courts, and in public debate, kind of as a reference point for thinking about these important issues. So the short answer is no obligation to implement our report or even to respond to it. But, we have a fair track record, a decent track record of getting our reports implemented and establishing parameters of public debates on these issues. I think that got it, those two questions, but if there's any follow-up, I'd be happy to address them. So.
Great, thank you, Nye. I think that answered a couple of other questions that were in the chat or in the Q&A as well. Thank you for that. I think before we wrap up, and I'll just note that I think what we're going to do is we'll take one more question that I think we'll cover off a couple questions in the Q&A. We'll do a couple of quick closing remarks. I'm going to stop the recording. And then if anybody wants to stay on the line after we finish, we can try to get to a couple more questions that are coming into the chat in the Q&A. If folks are interested in doing that, some of our panelists may be able to stay on and answer some more questions. But I do see a couple of questions in the Q&A in regards to Bill 23 and all of the notices that are up around Bill 23 right now. One regarding its implications on perhaps the timelines, but also there's a question up at the top here, and I've lost it now. I'm not sure where it went. Anyway, there was a question about Bill 23, and I'm wondering, Rick, maybe if you want to comment on sort of the ongoing process with Bill 23 and the EBR and the connections there.
Well, I think the gist of the questions is how could the EBR be amended to slow down or stop some of those initiatives? Someone raised a related question of, doesn't this make the law commission's consultation kind of moot or an exercise in futility, I think is the way they put it. And I think the short answer is no. I like to think about the possibilities. What if the EBR was amended to include the environmental principle known as non-regression, which basically prohibits rolling back or weakening existing environmental laws? That would make a difference. What if the EBR expressly imposed a public trust duty on the government? That would slow things down, especially if members of the public were enabled to go to court to strike down or set aside government activities that are inconsistent with that trust duty. What if these statements of environmental values included more substantive provisions, including public trust? That would make a difference. And as I say, what if citizens were able to, go to court and hold the government accountable for some of these activities? So that's why this is not a moot exercise. And I want to echo what Nye said as well. This is a long-term exercise. CELA was advocating for the Environmental Bill of Rights since the 1970s. It took until 1993 to get one in Ontario. We've had it for 25 years. It's time to, look at, possible reforms. And it may not happen during the term of this current government, but I, for one, would like to have a comprehensive, hard-hitting, off-the-shelf report from the Law Commission that I can wave around perhaps with the next government and say, well, look, this is what needs to happen if you're serious about environmental protection and safeguarding public health and safety. So that's my answer.
Thanks, Rick. Okay, I'm aware we're at 1:02. So right now I'm going to ask if any of the panelists have a last comment that they want to make.
I just wanted to say, in respect of Bill 23 and associated consultations, CELA staff, of course, are analyzing, as we do, deeply analyzing all of the proposals and providing our analysis to the public, to government. We either have now, or we are right in the process of setting up a quick landing page where, as we get those pieces done, we'll be posting them there so that you can access those. We haven't determined yet if we're going to run a webinar on that package, but I know some of our colleagues at other organizations are doing so.
Perfect. Thanks, Teresa. And yes, that's a landing page that will be coming soon. Okay. Did either Nye or Teresa, did you want to offer any concluding remarks before we wrap up the recording for today?
I'll just say, we have an absolute open door policy. If you have any questions, if you have any comments, anything, you've seen in our paper that's any background information you're interested in. We take our public consultation, and this sounds trite, but it's I hope it's true. And we take our public consultation, public engagement responsibilities very seriously. So if there's anything you want to know about the project, any comments, anything we can might interest you, just contact us, and we'll do our best to answer any and all questions as quickly as we can. But beyond that, I just invite everyone to participate, and thank you for the session. Thank you very much.
Thank you very much, Nye. And I will thank all of the panelists for taking the time to present today, and to everyone in the audience for giving us your lunch hour to talk about this. And we will be in touch soon. Thank you very much.